Thurgood Marshall passionately declared that classifications and distinctions based on race or color have no moral or legal validity in our society. They are contrary to our Constitution and laws. Throughout the history of our country, racial injustice has led to prejudice in all aspects of life, including social standing, the education system, and even positions in government. In the midst of the civil inequality in the 1940s and 1950s, Thurgood Marshall served as one of the true champions of equality in public education. Thurgood Marshall was born on July 2, 1908 in Baltimore, Maryland. As a child, he was aware that many African Americans did not enjoy the same rights as white Americans. His father worked as a waiter for an exclusive club, and his mother worked as a kindergarten teacher in an all-black school, earning less than the white teachers in white schools. From a young age, Marshall was raised to stand up for and even argue for things he believed in. Almost every night at the dinner table, Marshall, his father, and his brother would have heated arguments about almost everything. Marshall once said that his father never told me to become a lawyer, he turned me into one. Marshall was an above-average student and a star member of the debate team. He graduated high school in 1926 and attended the all-black Lincoln University. When he applied to the University of Maryland Law School, he was rejected due to his race. Instead, he went to Howard University Law School and graduated first in his class. It was during his time at Howard University Law School that Marshall met Dean Charles Hamilton Houston, who became one of his most important mentors. Marshall soon became Houston's right-hand man and helped him direct the National Association for the Advancement of Colored People, or NAACP, Legal Defense and Education Fund. Together, they successfully argued for the integration of University of Maryland's Law School, where Marshall stated that, "What's at stake here is more than the rights of my client. It is the moral commitment stated in our country's creed that the separate but equal doctrine of the 14th Amendment be upheld for all races." Marshall's first-hand experience of discrimination made a lasting impression and clearly shaped and determined his future convictions and career in championing civil rights. Although he had many great and notable achievements, one of the key cases that earned Marshall the name Mr. Civil Rights was the landmark class action lawsuit, Brown versus the Board of Education, which challenged school segregation in the public school system. The Brown versus Board of Education suit was a compilation of 5 cases brought to court by the NAACP from 5 different states, including Kansas, Delaware, Washington, D.C., South Carolina, and Virginia. Each of these cases argued that there was a violation of the 14th Amendment's Equal Protection Clause. All 5 cases were ones appealed to the Supreme Court and were consolidated under the name Brown versus the Board of Education of Topeka for several strategic reasons. First, Mr. Brown, a minister, and his wife, Mrs. Brown, a teacher, were both respected members of their community. Secondly, they came from a non-Southern state, and the NAACP wanted to make a point that segregation was a national issue. Third, since the district court found that the all-white and all-black schools were roughly equal in Topeka, the focus could be on abolishing segregation and not on the separate but equal idea. Mr. and Mrs. Brown joined the lawsuit on behalf of their daughters, Cheryl and Linda. Linda had to walk a mile every day to get to her all-black school when there was an all-white school just 7 blocks away. At the urging of the Topeka, Kansas NAACP chapter, Mr. and Mrs. Brown, as well as 11 other parents, attempted to enroll their children in the all-white schools closest to their homes. Although the district court found in favor of the school board and upheld the separation of schools, it did note that the segregation of white and colored children in public schools has a detrimental effect upon the colored children, and that the impact is greater when it has the sanction of law. Marshall, who served as the NAACP chief counsel for the case, used this evidence to argue his case, for the first time citing psychological studies which showed that segregation was discriminatory and emotionally damaging. Another one of the cases consolidated under Brown was the Davis versus the School Board of Prince Edward County case. This lawsuit was different in that it was brought by the students themselves. Barbara Rose Johns organized 450 African American fellow high school students to strike for 2 weeks rather than attend the all-black Mountain High School, which was badly in need of physical repair. Only one of 15 buildings in the school had restrooms, and the school served 450 students when it had been built for only 180 students. Classes had to overflow into school buses. Barbara was the niece of Vernon Johns, a minister who had served in the Dexter Street Baptist Church 10 years before Martin Luther King Jr. He was known to support anti-segregation and had previously organized other protests and strikes. Johns was reported by the community to have been an advisor to the students. The Student Strike Committee asked for help from the NAACP, who filed a suit on behalf of 117 of the students. Despite the obvious disparity between the all-white schools and Mountain High School, the district court unanimously ruled against the students. When the Supreme Court ordered desegregation after the Brown case, white Virginians violently rejected the ruling. They refused to give any funds to the county school board, effectively shutting down the public schools while launching a private, white-only educational program. Even when the public schools were forced to reopen 5 years later, the public schools remained essentially black-only schools, continuing the segregated system. Marshall always felt that in order for the African Americans to thrive and succeed, they needed to receive a proper education. However, this could not be achieved due to the segregation found in the school system in the 1940s and 1950s. As a result of his early life and ambition for racial equality, he found himself arguing one of the most significant cases to officially end segregation in American public schools. Challenging segregation in school systems nationwide, Thurgood Marshall convincingly pointed out that if all students were indeed equal, then why was it necessary to separate them? He also argued that during the day, those same students would play in the streets together, they would play ball together, they would grow up together, but when it came to their education, it was required that they were separated. In 1954, the Supreme Court unanimously declared that in the field of public education, the terms separate but equal had no place, and therefore separate educational facilities were deemed inherently unconstitutional and unequal. Thurgood Marshall traveled throughout the United States as an attorney for the NAACP from 1934 to 1961. He argued 32 cases before the Supreme Court and won in 29 of them. He was appointed to the Court of Appeals by President John F. Kennedy in 1961, and in 1965, President Lyndon B. Johnson appointed him to the Supreme Court as its first black justice. Thurgood Marshall, Mr. Civil Rights, was known for his egalitarian views and for his always standing up for educational equality and civil rights. His work has changed how we as Americans see equality in education.